Question 1. Topic: Easements and encroachments when implementing new protocols in a shared environment where multiple property owners have historically used a common access road. A dispute arises regarding whether one owner can block another from using the road. The dominant owner claims an easement by prescription, while the servient owner argues that the use was merely permissive and not adverse. What is the most legally sound resolution to this dispute? A. The servient owner can block access because an easement by prescription requires exclusive use, which is not met in a shared access scenario. B. The dominant owner has a valid prescriptive easement if the use was open, continuous, notorious, and hostile for the statutory period. C. The dominant owner cannot claim an easement by prescription unless a written agreement exists between the parties. D. The servient owner must prove that the use was explicitly permitted and not adverse. Otherwise, the prescriptive easement stands. Answer: B. The dominant owner has a valid prescriptive easement if the use was open, continuous, notorious, and hostile for the statutory period. Explanation: an easement by prescription is created when a party uses another's land in a way that is open, continuous, notorious, and hostile for the required statutory period, which varies by jurisdiction, typically between 10 to 2 years. The dominant owner in this case argues use was prescriptive, meaning it was without permission and uninterrupted for the statutory period. Option is incorrect because exclusivity is not a requirement for prescriptive easement. The multiple parties can use the land and still meet the requirements. Option C is incorrect because prescriptive easements arise through use, not written agreement. Written agreement would instead create an express easement. Option D is partially correct in stating that the servient owner can challenge the claim by proving that permission was explicitly granted. However, if no evidence of permission exists, the dominant owner's claim prevails. Relevant law: prescriptive easements doctrine, statutory adverse possession rules. Question 2. Topic: Real estate financing and mortgages during a major transformation where existing methods of property financing are being reassessed. A borrower takes out an adjustable rate mortgage armed with a 3-1 structure. 3 years later, interest rates rise sharply, leading to significantly higher payments. The borrower argues that the lender failed to adequately disclose the risks of interest rate fluctuations. Under the Truth in Lending Act, TILA, what is the borrower's best legal argument? A. The lender violated TILA if they failed to clearly disclose that the interest rate could increase and by how much. B. The borrower has no recourse under TILA since adjustable rate mortgages are inherently risky and the burden is on the borrower to understand the terms. C. The lender can modify the loan terms retroactively to accommodate the borrower's financial hardship. D. The borrower can automatically rescind the loan under TILA's right of rescission because the terms were unfavorable. Answer A. The lender violated TILA if they failed to clearly disclose that the interest rate could increase and by how much. Explanation: the Truth in Lending Act, TILA, requires lenders to fully disclose loan terms, including potential rate adjustments, caps, and worst-case scenarios for adjustable rate mortgages arms. If the lender failed to inform the borrower about the magnitude of rate increases, payment recalculations, or index adjustments, borrower may have a claim for a TILA violation. Option B is incorrect because while borrowers are responsible for understanding their loans, TILA imposes a duty on lenders to make disclosures in a clear, prominent manner. Option C is incorrect because lenders are not obligated to modify loans retroactively due to interest rate changes unless fraud or non-disclosure occurred. Option D is incorrect because TILA's right of rescission applies primarily to certain home equity loans and refinances, not purchase mortgages. Relevant law: Truth in Lending Act, TILA, Real Estate Settlement Procedures Act, RESPA, Consumer Financial Protection Bureau, CAB, regulations. Question 3. Topic: Landlord-tenant law, evictions and tenant protections while managing hybrid approach where timing issues affect lease renewals. Landlord in rent-controlled jurisdiction serves tenant with 30-day no-cause eviction notice. The tenant has paid rent on time for years and has not violated any lease terms. The landlord claims the right to evict under state landlord-tenant law, while the tenant asserts that the eviction violates local rent control protections. Under which condition is the eviction most likely unlawful? A. The eviction is unlawful if local rent control laws require just cause for termination and the landlord fails to provide legally valid reason. B. The eviction is lawful because landlords have the right to remove tenants once lease expires, regardless of rent control protections. C. The eviction is unlawful because all tenants in rent-controlled units are protected from eviction under any circumstances. D. The eviction is lawful if landlord offers compensation equal to 1 month's rent as required by state tenant relocation laws. Answer A. The eviction is unlawful if local rent control laws require just cause for termination and the landlord fails to provide a legally valid reason. Explanation. Many rent control jurisdictions require landlords to establish a just cause before evicting a tenant, even at the end of a lease term. Just cause reasons typically include non-payment of rent, lease violations, substantial property renovations, or owner move-in. No, cause eviction is generally prohibited unless the landlord meets an allowable exception under rent control regulations. Option B is incorrect because rent control laws override general landlord-tenant statutes that allow termination at the end of a lease. Option C is incorrect because while rent control laws provide protections, tenants are not immune from eviction under all circumstances. Option D is incorrect because offering compensation may be required for certain types of no-fault evictions, but it does not automatically make the eviction lawful. Relevant law: local rent control ordinances, Tenant Protection Acts, just cause eviction laws. Question 4. Topic: adverse possession and squatters' rights in high-stakes environment where multiple challenges exist in determining rightful property ownership. Landowner discovers that neighbor has been using portion of their land for over 15 years. The neighbor has built small shed, maintained the area, and openly claimed it as their own without the landowner's permission. The landowner now wants to reclaim the land. Given the legal doctrine of adverse possession, which following is the most accurate legal outcome? A. The landowner can immediately reclaim the land because they hold legal title regardless of the neighbor's actions. B. The neighbor may acquire legal ownership if they meet the legal requirements of adverse possession, which include open, notorious, continuous, exclusive, and hostile use for the statutory period. C. The landowner can only reclaim the land if they prove the neighbor was aware they were trespassing and continued to do so despite multiple warnings. D. The neighbor can claim the land only if they had written permission from the landowner to use it for over 15 years. Answer B. The neighbor may acquire legal ownership if they meet the legal requirements of adverse possession, which include open, notorious, continuous, exclusive, and hostile use for the statutory period. Explanation: adverse possession allows a trespasser to acquire legal title to land if their possession meets specific requirements over a statutory period. Most U.S. states require possession to be open and notorious, visible and obvious to the public and the owner, continuous, uninterrupted for the statutory period, often ranging from 10 to 2 years, depending on state law. Exclusive: the trespasser is the sole user, not sharing possession with the owner or public. Hostile: without the owner's consent. The neighbor meets these conditions by maintaining and using the land for over 15 years without permission. Answer A is incorrect because adverse possession can override the landowner's legal title. Answer C is incorrect because knowledge of trespassing is not required. Some jurisdictions allow adverse possession even if the trespasser mistakenly believed they own the land. Answer D is incorrect because adverse possession requires unauthorized use. Permission negates the hostile requirement. Relevant law: adverse possession statutes vary by state but typically follow these principles under common law and state-specific property codes. Question 5. Topic: eminent domain, escheat taxation, and police power during a major transformation where existing methods of urban planning are being restructured. A city government decides to seize private property to build a public transportation hub. The affected property owner argues that the government is overstepping its legal authority and challenges the action in court. Under which legal doctrine can the government justify this seizure, and what are the property owner's rights? A. The government can seize the property under eminent domain, but they must provide just compensation. B. The property owner has the absolute right to reject the government's decision and cannot be forced to sell their land. C. The government can seize the land under police power as public transit projects are in the interest of public safety and welfare. D. The government cannot take private land for public project unless the property owner voluntarily consents. Answer A. The government can seize the property under eminent domain, but they must provide just compensation. Explanation: under the Fifth Amendment's takings clause, the government has the right to eminent domain, allowing it to take private property for public use with just compensation. The courts have broadly interpreted public use to include highways, public transit, and economic redevelopment projects. However, the property owner has the challenge necessity and public use. If the government fails to prove that the project benefits the public, the owner may challenge the taking just compensation. The owner can dispute the valuation of their property to ensure fair market compensation. Answer B is incorrect because eminent domain allows the government to seize private land against the owner's will provided just compensation is given. Answer C is incorrect because police power allows regulation but does not permit the government to take private land without compensation. Answer D is incorrect because eminent domain does not require voluntary consent. Relevant law, Kelo v. City of New London, 2005, expanded the definition of public use under eminent domain. Question 6. Topic: Real estate contracts and agreements. While analyzing the root causes of sequential problems in real estate transactions, a buyer enters into a purchase agreement with the seller. The contract contains an appraisal contingency that states the buyer may cancel the contract if the property is appraised below the agreed purchase price. After the appraisal comes in significantly lower, the buyer decides to back out. However, the seller argues that the buyer is in breach of contract. What is the most likely legal outcome? A. The buyer is in breach of contract because the appraisal contingency is only valid if the seller also agrees to it. B. The buyer can terminate the contract legally as appraisal contingencies are enforceable clauses that allow withdrawal if the appraisal is lower than expected. C. The buyer must continue with the purchase, but the seller is required to lower the price to the appraised value. D. The seller can sue for specific performance to force the buyer to complete the purchase despite the appraisal. Answer B. The buyer can terminate the contract legally as appraisal contingencies are enforceable clauses that allow withdrawal if the appraisal is lower than expected. Explanation: an appraisal contingency protects buyers by allowing them to withdraw from the purchase agreement without penalty if the property does not appraise at or above the agreed upon price. This prevents buyers from being contractually obligated to overpay. Answer A is incorrect because contingencies in a contract do not require separate approval from both parties at the time of execution. They apply if included in the signed contract. Answer C is incorrect because a seller is not legally obligated to adjust the price to match the appraised value unless specified in the contract. Answer D is incorrect because specific performance is not typically granted when contingencies allow withdrawal. Relevant law, contract law principles regarding contingencies, breach of contract and remedies apply here. Uniform Commercial Code and common law contract doctrines support the enforceability of such clauses. Question 7. Topic: Zoning and land use planning. As the competition grows stronger in the real estate development sector, a property owner wants to build a commercial store in a residentially zoned area. What legal process allows them to request an exception? A. Eminent domain. B. Variance. C. Fee simple estate. D. Covenant restriction. Answer B. Variance. Explanation: a variance is a legal exception granted by local zoning authorities allowing property use that differs from zoning laws, provided it does not harm public interest. Question 8. Topic: Real estate contracts and buyer-seller disputes. In response to increasing public demand for fair housing practices, a buyer agrees to purchase a home, but the seller later refuses to close the deal. What is the buyer's best legal remedy? A. Specific performance. B. Rescission of contract. C. Adverse possession. D. Quitclaim deed. Answer A. Specific performance. Explanation: specific performance is a legal remedy in which a court orders the breaching party to fulfill their contractual obligations instead of paying monetary damages. Question 9. Topic: Title disputes and ownership claims. Given the unpredictable nature of title disputes in real estate transactions, a homeowner learns that a previous owner's heir is claiming legal ownership of their property. The homeowner has title insurance. What should they do? A. Ignore the claim as title insurance guarantees ownership. B. File quiet title action in court. C. Negotiate lease with the heir. D. Relinquish ownership voluntarily. Answer B. File a quiet title action in court. Explanation: a quiet title action is a lawsuit used to settle disputes over property ownership and establish a clear title. Question 10. Topic: Landlord tenant law and eviction procedures. While facing an urgent need for stability in rental agreements, a tenant receives an eviction notice but believes it was issued unfairly. What legal defense might the tenant use? A. Implied warranty of habitability. B. Easement by prescription. C. Fee simple defeasible. D. Covenant of seisin. Answer A. Implied warranty of habitability. Explanation: If the rental unit is uninhabitable, e.g., lacking heat, water, or proper maintenance, the tenant may argue that the landlord violated the implied warranty of habitability, potentially delaying or preventing eviction. Question 11. Topic: Easements and property access rights. After a meticulous review of past cases involving easement disputes, a property owner blocks a shared driveway that has been used by their neighbor for decades. The neighbor sues, claiming a right to use the driveway. What type of easement might apply? A. Easement by necessity. B. Special warranty easement. C. Adverse possession. D. Revocable license. Answer: A. Easement by necessity. Explanation: an easement by necessity is granted when a landlocked property owner must cross another's land to access public road. Question 12. Topic: Deeds and property transfers. Considering the financial implications of different deed types, a homebuyer wants to ensure the seller guarantees clear title with no past claims against the property. Which type of deed provides the strongest protection? A. Quitclaim deed. B. General warranty deed. C. Special warranty deed. D. Bargain and sale deed. Answer: B. General warranty deed. Explanation: a general warranty deed provides the strongest protection, ensuring the property is free of liens, encumbrances, or title defects, covering both past and present claims. Question 13. Topic: Encumbrances and financial liens on property. While implementing a strategy to resolve an outstanding debt, a homeowner discovers that a mechanic's lien has been placed on their property by contractor. What legal action can they take? A. File lawsuit to remove the lien. B. Ignore the lien until the property is sold. C. Transfer ownership to relative to avoid the lien. D. Terminate the contractor's business license. Answer: A. File a lawsuit to remove the lien. Explanation: if the homeowner believes the lien is invalid, they may file a lawsuit to remove discharge of the lien or negotiate payment terms to satisfy the debt. Question 14. Topic: Landlord responsibilities and tenant protections. In a high-stakes environment where multiple challenges exist in ensuring tenant rights, a landlord fails to provide necessary repairs, leaving the rental unit without running water. What legal doctrine allows the tenant to withhold rent or move out without penalty? A. Covenant of quiet enjoyment. B. Constructive eviction. C. Subrogation rights. D. Escheat. Answer: B. Constructive eviction. Explanation: constructive eviction occurs when a landlord's failure to maintain habitable conditions forces tenant to vacate. The tenant may also withhold rent or sue for damages. Question 15. Topic: Foreclosure, mortgage default. During a major transformation where existing methods of home financing are being questioned, a homeowner falls behind on mortgage payments. The lender initiates foreclosure, but the homeowner wants to reclaim the property before the sale. What legal right allows them to do so? A. Right of redemption. B. Mortgage acceleration. C. Adverse possession. D. Easement by necessity. Answer: A. Right of redemption. Explanation: right of redemption allows a borrower to reclaim their foreclosed property by paying off the outstanding debt before the sale is finalized. Question 16. Topic: Real estate disclosures and seller obligations. While analyzing the root causes of sequential problems in home transactions, a seller fails to disclose a known mold infestation before selling a home. The buyer later discovers the issue. What legal action can the buyer take? A. File a claim for fraudulent misrepresentation. B. Request a new appraisal. C. Invoke the statute of frauds. D. Demand a leaseback agreement. Answer: A. File a claim for fraudulent misrepresentation. Explanation: sellers are legally required to disclose known material defects. Fraudulent misrepresentation occurs when the seller knowingly withholds or lies about property conditions. Question 17. Topic: Eminent domain and government seizure of property. As the competition grows stronger in the real estate development sector, the government seizes a homeowner's land to build highway, offering fair compensation. What legal principle allows this? A. Adverse possession. B. Easement by prescription. C. Eminent domain. D. Fee simple determinable. Answer: C. Eminent domain. Explanation: under eminent domain, the government has the right to take private property for public use provided fair compensation is given to the owner. Question 18. Topic: Title defects and ownership disputes. In response to increasing public demand for transparency in property transactions, a buyer discovers that their newly purchased home has an unresolved lien from a previous owner. What legal document could have protected them? A. Quitclaim deed. B. Title insurance. C. Constructive notice. D. Equitable servitude. Answer: B. Title insurance. Explanation. Title insurance protects buyers from hidden title defects such as liens, forgeries, or conflicting ownership claims. Question 19. Topic: Land use regulations and zoning laws. Given the unpredictable nature of zoning law enforcement, a developer wants to build an apartment complex in an area zoned for single-family homes. What legal process allows them to seek an exception? A. Fee simple ownership. B. Variance. C. Novation. D. Eminent domain. Answer: B. Variance. Explanation. A variance is a request for an exception to zoning laws, allowing land use that would otherwise be restricted. Question 20. Topic: Real estate contractual obligations and buyer remedies. While facing an urgent need for stability in real estate contracts, a buyer enters into an agreement to purchase a home, but the seller backs out after accepting a higher offer from another buyer. What is the most appropriate legal remedy? A. Specific performance. B. Easement by estoppel. C. Tenancy by the entirety. D. Liquidated damages. Answer: A. Specific performance. Explanation. Specific performance allows a court to enforce the contract, compelling the seller to complete the sale under the agreed terms. Question 21. Topic: Escrow accounts and earnest money deposits. After a meticulous review of past cases involving escrow disputes, a buyer places an earnest money deposit in escrow but later cancels the contract due to a failed inspection. Who is entitled to the deposit? A. The seller automatically keeps the deposit. B. The real estate agent. C. The buyer, unless otherwise stated in the contract. D. The escrow officer decides based on local laws. Answer: C. The buyer, unless otherwise stated in the contract. Explanation. Earnest money deposits are typically refundable if a contract is cancelled for a valid reason, such as a failed inspection or financing contingency. Question 22. Topic: Liens and encumbrances on property. Considering the financial implications of unpaid property taxes, a homeowner ignores property tax bills for several years. What action can the government take? A. Place a tax lien on the property. B. Require the homeowner to refinance. C. Force the sale to a private investor. D. Convert the property into a leasehold estate. Answer: A. Place a tax lien on the property. Explanation. A tax lien is a legal claim placed on a property due to unpaid taxes. If unresolved, the government can sell the property through a tax lien foreclosure. Question 23. Topic: Joint ownership and survivorship rights. While implementing a strategy to prevent inheritance disputes, two siblings own a home as joint tenants. One sibling passes away. What happens to their ownership share? A. It passes to their heirs. B. It is divided among all living relatives. C. It automatically transfers to the surviving joint tenant. D. It is auctioned off by the local government. Answer: C. It automatically transfers to the surviving joint tenant. Explanation. Joint tenancy with right of survivorship ensures that when one owner dies, their share automatically passes to the surviving co-owner, avoiding probate. Question 24. Topic: Adverse possession and property rights. Given the ever-growing complexity of property disputes, a person has been living on a vacant piece of land openly and without permission for 15 years. The legal owner has not attempted to remove them. Under what legal doctrine might the trespasser gain ownership of the land? A. Easement by prescription. B. Constructive eviction. C. Adverse possession. D. Fee simple defeasible. Answer: C. Adverse possession. Explanation. Adverse possession is a legal doctrine allowing a person to claim ownership of land if they occupy openly, continuously, and without the owner's permission for a legally required period, which varies by state. This doctrine is designed to encourage landowners to monitor and use their property. In most states, the claimant must meet specific conditions: actual possession, the person must physically occupy the property, live on it, farm it, or build structures. Open and notorious, the possession must be visible and obvious to the public and the legal owner. Exclusive and continuous, the person must use the land without interruption for the required statutory period, often 7 to 20 years, depending on state law. Hostile claim, the use must be without the owner's consent, not necessarily aggressive, just unauthorized. If these conditions are met, the trespasser can legally obtain title to the property. Question 25. Topic: Easements and land use rights. As real estate transactions become more intricate, a homeowner discovers that their neighbor has been using their private driveway for years to access the main road. The homeowner never gave explicit permission but also never objected. What type of easement may have been created? A. Easement by necessity. B. Easement by prescription. C. License agreement. D. Fee simple absolute. Answer: B. Easement by prescription. Explanation: an easement by prescription occurs when someone continuously and openly uses another person's property without permission for legally required time, similar to adverse possession but for use rights, not ownership. The legal requirements often include open and notorious use. The use is visible and obvious, continuous and uninterrupted. The person must use the property for a period defined by state, often 2 years. Hostile claim: the use occurs without the owner's explicit permission. Because the homeowner never objected over the years, the neighbor may have gained legal right to continue using the driveway under prescriptive easement laws. Question 26. Topic: real estate fraud and misrepresentation. In a high-stakes environment where buyers rely on seller honesty, a homeowner knowingly fails to disclose that their house has a cracked foundation which affects the property's safety. The buyer purchases the home and later discovers the issue. What legal claim can the buyer file? A. Fraudulent misrepresentation. B. Escheat. C. License revocation. D. Assignment of contract. Answer: A. Fraudulent misrepresentation. Explanation: fraudulent misrepresentation occurs when a seller intentionally conceals or lies about a material defect in a property. This claim requires proof that the seller knew about the defect and deliberately failed to disclose it. The buyer relied on the seller's statements or omissions when making the purchase. The defect significantly affects property value or livability. The buyer suffered financial harm. Result: remedies for fraudulent misrepresentation can include rescinding the contract, suing for damages, or forcing the seller to pay for repairs. Many states have strict real estate disclosure laws, requiring sellers to disclose known defects even if the buyer doesn't ask. Question 27. Topic: tenancy types and ownership rights. Given the legal uncertainties surrounding property co-ownership, two business partners purchase a commercial property together. The deed states that if one partner dies, their share automatically passes to the surviving partner. What type of ownership do they have? A. Tenancy in common. B. Joint tenancy with right of survivorship. C. Leasehold estate. D. Life estate. Answer: B. Joint tenancy with right of survivorship. Explanation: in joint tenancy with right of survivorship, two or more owners share equal ownership rights. The key characteristic is the automatic transfer of ownership upon a co-owner's death, avoiding probate. Joint tenancy requires unity of time. Owners acquire the property at the same time. Unity of title. Owners have the same deed and ownership rights. Unity of interest. Each owner has an equal. Unity of possession. Each owner has equal access to the entire property. If one partner dies, their interest automatically transfers to the surviving partner, overriding any will or inheritance claims. Question 28. Topic: lease agreements and tenant rights. As rental disputes increase in competitive housing markets, a tenant signs a 1-year lease but wants to leave after 6 months. What legal obligation does the tenant have in this situation? A. The tenant can leave without penalty since leases are flexible. B. The tenant must continue paying rent unless the landlord finds a new tenant. C. The landlord must refund all prepaid rent. D. The lease automatically converts to a month-to-month agreement. Answer: B. The tenant must continue paying rent unless the landlord finds a new tenant. Explanation: a lease is a binding contract and breaking it early does not automatically release the tenant from financial obligations. However, many states require landlords to mitigate damages by attempting to find a new tenant. If a replacement tenant is found, the original tenant may be responsible for rent only until the new lease begins. In cases that the tenant may also pay early termination fees outlined in the lease. Options for tenants: subletting, if allowed in the lease, negotiating an early termination agreement with the landlord using a lease break clause if included in the contract. Tenants should carefully review lease agreements before signing to understand the penalties for early termination. Question 29. Topic: title transfers and deed types. In an era where property transactions are rapidly evolving, a seller transfers ownership of a property using a deed that provides no warranties and only conveys their interest in the property. What type of deed is this? A. General warranty deed. B. Quitclaim deed. C. Special warranty deed. D. Bargain and sale deed. Answer: B. Quitclaim deed. Explanation: a quitclaim deed transfers whatever interest the seller has without guarantees about title quality. This means if the seller has full ownership, the buyer gets full ownership. If the seller has no legal claim, the buyer gets nothing. Quitclaim deeds are often used in family transfers, divorce settlements, and fixing title defects, but they do not protect buyers from title defects, unpaid liens, or competing ownership claims. Buyers who need strong title protection should request a general warranty deed which guarantees clear ownership. Question 30. Topic: Fair housing laws and discrimination protections. As the real estate industry works to uphold ethical standards, a landlord refuses to rent to a prospective tenant because they have children. What federal law prohibits this practice? A. The Fair Housing Act. B. The Statute of Frauds. C. The Homestead Act. D. The Equal Credit Opportunity Act. Answer: A. The Fair Housing Act. Explanation: the Fair Housing Act (FHA) prohibits discrimination in housing based on race, color, religion, sex, disability, familial status, or national origin. Refusing to rent to someone because they have children is familial status discrimination, which is illegal under the FHA. Landlords cannot impose restrictions on tenants based on children, such as banning them from certain units or neighborhoods. Exceptions exist for senior living communities designed for 55 residents.